Good morning to all of you. Video number 1422. In this video, we are going to discuss mens rea. Friends, I think for the past 3 days, we have been discussing on the law of torts. You all know, tort is a civil wrong, not a criminal wrong. Tort is a civil wrong which is not exclusively a breach of trust or a breach of contract. And when the legal injury is caused, it is compensated with unliquidated damages. The remedy is unliquidated damages. You all know the meaning. So you have to cut the definition into 3 parts. Tort is a civil wrong, first part. Second, it should cause legal injury. Please remember, legal injury, not ordinary injury. Injury means not physical injury, even mental agony is also legal injury. Then how it will be compensated? It will be redeemed by awarding the compensation in the shape of unliquidated damages. Unliquidated means undefined. The judge may award 1 rupee, the judge may reward 1000 rupees also. It is not quantified. That's the main problem here. And you all know that the judge will use his personal discretion in awarding the compensation because tort is not a codified law. And in this tort, mens rea is not at all necessary. Mens rea is not at all necessary. Of course, sometimes it will be there. For crimes, mens rea is 100% necessary. Whereas for torts, it is not that necessary. Then you may be confused. What is this mens rea? Mens rea, please remember, it is nothing but guilty intention, guilty mind, bad ideology. So, guilty mind, a person. So that's why I have told you the 2 legal maxims, mens rea and actus reus. So actus reus, mens rea means guilty intention and actus reus means voluntary act. So doing some act voluntarily, right? So this mens rea is an important part in committing the crime, particularly in the crime. Crime means law, civil wrong. Crime is criminal wrong. So tort is a civil wrong. In crime, definitely mens rea should be there. Incidentally, in India, there is no mention of mens rea, but actually this is basically an English concept. Mens rea is an English concept. In India, it is not there. Even in 1860s, Lord Macaulay's Indian Penal Code also, it is not mentioned. But please remember, it is mentioned in the other names. By name, voluntarily, fraudulently, dishonestly, knowingly, all these things. So in this connection, I want to tell you a legal concept, that is actus non facit rem. Actus non facit rem nisi mens rea. So please remember, the act does not render a person liable for guilty unless his thought is also guilty. That means when you do not have a guilty mind, even though you do some action, it is not an offense. That is what is stated in IPC. You may be nearing the general exceptions right from 76 to I think 106, not 106. You can discuss because 99 and 106 is self-defense. So 76 to 106 deal with the general exceptions. That means suppose if a boy throws his sister into boiling water and she receives injuries, if the boy is aged about 7 years or so, the exception will come because he is innocent. He does not know the consequences of the law. So this is what is called mens rea. So please remember, for an act or for a crime to be done, so there should be some motive, there should be some intention, there should be some preparation, there should be some attempt, then only the act will come. So intention. First of all, one should have some motive. What is the motive? Motive is the driving force. That means wanted to do something. Intention, how to do that thing. Act, preparation. So preparing all these things. Other attempt and act I need not tell in detail. So if these things are there, definitely the act is committed. If it is committed voluntarily, that is what is called actus reus. Voluntarily. That means, simple example I will give you. If A inflicts an injury on B without any excuse, it is an offense. That's why section 323 says voluntarily. Suppose if B comes to hit A and A in the exercise of private defense or self-defense, if he hits B, then it is not at all an offense, because it is generally excluded by the so-called right of private defense under section 99 of the RPC. So this is the main difference. Please remember, mens rea means bad intention. Actually, this was recognized way back in 12th century by the English common law principles, but it has come into existence, I think, from 17th century onwards. So in Indian law, mens rea is not there. In the name of voluntarily, you may be referring to, I think, section 29. What is voluntarily? Knowingly or having a reason to believe you do something, then it is an offense. Dishonestly, intention. So if you want to get wrongful gain, dishonestly. Then knowingly, having awareness of one's own actions. So fraudulently, rashly, negligently, all these words, they are synonymous, but they are synonymous for mens rea. Anyway, to conclude, I want to tell you, mens rea is not an important element in the law of torts. But as law students, since you are in the beginning stage, I am giving this topic, even though it comes majorly in crimes, but you have to know, since you are in the beginning, as I already, you are beginning stage, better to know what is mens rea, what is actus reus, and please remember the legal maxim, actus non facit rem nisi mensi 3. Actually, we have to pronounce it like that, right? Anyway, thank you very much.